Please welcome to the stage RPAG Vice President, Jeff Cheshier.
Hello, RPAG. How we doing? What a beautiful crowd. You know, I was in the back earlier, and a lot of people were standing up. And Jesse's like, hey, man, there's lots of seats up front. Didn't look like it. There's seats up front. If anybody's standing in the back, come on up. Thank you so much for being here. We are here to have a discussion of our ERISA updates. I would like to welcome Jenny Kiffmeyer, who is COO of the RLC, Retirement Learning Center, and a new face on stage, John Nelson, we haven't had before.
It just looks new. It's still the same old.
Fresh out of the shop. Jenny, tell us a little bit about yourself.
Sure. I'm with the Retirement Learning Center. We are a training and education firm that focuses exclusively on financial advisors in the retirement space. This is our 20th year, and I've been at it for 30 years.
May I have the clicker, please?
Oh, absolutely.
Thank you. John,
Yeah, so
tell us a little bit about yourself.
Yeah, so John Nelson. I'm an ERISA attorney with NFP, and been here a few times with the conference and looking forward to speaking again today. Thank you very much.
Wonderful. Well, at the outset, I know that this is a voluminous topic, and it could probably go 3 or 4 hours, and we would not necessarily cover everything. We are not going to be able to cover everything, but these slides that I believe all are going to be available for download after this, after conference wraps, is going to include a lot of content. So if there is anything that Jenny or John talks about that you'd like to know more about, be sure and download those slides, and there's going to be a lot of detail available. So Jenny, would you please maybe kind of set the tone for us a bit about how our audience can receive and put to use the information that you and John are going to be talking about today?
Absolutely. Well, you probably have heard of a little thing called Secure Act 2.0. It's been about the primary news coverage item in the industry since it was passed the end of 2022. There were over 90 provisions in the new law. There are a variety of different effective dates, and there will be plan amendments due. So with this beast of a law, how do you tackle it? How does a plan sponsor tackle it, and plan committees and the advisors who are assisting them? Well, it reminds me of the saying, how do you eat an elephant? One bite at a time. And that's the way plan sponsors can take a look at trying to understand and incorporate the Secure Act provisions. Now, I mentioned there are over 90 of them. However, there are just a handful that are mandatory. So we know that those will have to be added to plans, but the rest are all optional provisions. And so in order to decide what to add of the optional provisions, plan sponsors and committees and the advisors who help them really should have a prudent process in place. That's a common phrase, prudent process, to be able to evaluate the various optional provisions, decide using the core criteria of what's in the best interest of plan participants and beneficiaries for reasonable fees. So they're going to need to look at their own employee demographics and look at the variety of optional provisions and decide, is this something that is in the best interest of my participants? If so, let's document that, why that is a good decision, and make sure we've got that in our meeting minutes. That's another key phrase that came up earlier today. Put it in the meeting minutes and make sure the document then reflects the addition of those provisions. I know, John, if you wanted to add anything to that, or?
No, I think that covers it pretty well. Yeah,
Right.
I think we can kind of dive into some of the things.
Right.
Yesterday we talked about adding value as a plan advisor, and I think that's what we want to take away from today's meeting, just some things you should be talking with your clients about today in regard to Secure Act 2.0.
Right.
Awesome. Well, John, let's take the first bite. I know that the catch-up contributions is something that has caused a little bit of consternation. What's the latest there?
Okay, so this, I'll tell you, if you only take one thing away from today's meeting, this is the most important. Mandatory for 2024 and later, and that is highly paid participants that make more than $145,000 in the prior year. If they want to make catch-up contributions, those contributions have to be made on a Roth basis. So the concern is if your plan doesn't already allow for Roth contributions, you've got to amend the plan by December 31st, 2023, to add the Roth provision.
John, notice 2362?
Oh, that's right. Never mind. No, all kidding aside, this provision has actually now been extended for 2 years. So you don't have to amend by the end of this year. Your high-paid folks, remember, it's $145,000, and why on earth Congress added that as a dollar limit as opposed to dollar limits we already have for highly compensated employee definition, who knows? But the point is that you don't need to worry about this for 2 more years. The rules are the same for 24, 25. This will be effective 1/1/2026. Okay?
Right.
Great, thanks.
Awesome. Well, John, to date,
Yep.
I have been the only one who has been able to make Roth contributions to my plan account. How is that changing with Secure?
Well, so here's an interesting provision. Now, this talks about, what we're talking about here is the employer contribution. And this provision is effective right now. This is an optional provision, as Jenny mentioned, optional versus mandatory. Under this provision, a participant can elect to treat employer money going into the plan as Roth dollars. Now, this applies to both 401k, 403b, and government 457b. And if you think about it, it probably applies to a garden variety profit sharing plan as well that has employer money going in with no employee deferrals. Because it's a way for the employee to elect Roth treatment for the employer contribution. Now, I'll tell you, there's a lot of questions on how this is going to work. We need guidance from the IRS. I'm not aware of a single record keeper or provider that's doing this yet because you can't figure out, like some of the questions. Now, if I'm the employee and I elect to Roth my employer account, I'm responsible for those taxes. But now, does that increase my FICA Medicare wages? Probably not, but we don't know. How does it get reported? Is it W-2? Is it 1099? I don't know. It's probably not counted as compensation for plan purposes. So I just want you to be aware of this provision if somebody brings it up, but it's something, because it's effective right now, but it's something we definitely need guidance on.
Okay.
All right.
Jenny, what's an LTPT?
It's a long-term part-time employee. I'm sure you know many of your business owners who employ part-time employees. This is actually a provision that was adopted in Secure Act 1.0 and has been already amended, even though it's not in place, amended in 2.0. So under 1.0, if a long-term part-time employee has 500 or more hours in the 3 consecutive years prior to 2024, they will need to be eligible to defer into a plan beginning 2024. So already, plan sponsors should have been counting these part-time hours for 21, 22, and 23 for each 500 hours for those 3 years so that the individual, if they qualify, can start deferring right away in 2024. What Secure 2.0 did was reduce this 3-year period to 2 years. So come 2025, we'll be looking at the 2 prior years to determine who is eligible to participate as a long-term part-time employee.
Could I just add a couple of things real quick? So remember, this is just employee deferral only.
Correct.
They don't have to be eligible for employer money, just employee deferral only. So if you've got plans out there that are excluding part-time employees, this is applicable to you. And the other thing I want to mention is Jenny mentioned this changes for 2025. Mm-hmm. It's also in 2025 applicable to ERISA-covered 403B plans. So if you've got a 403B plan out there that has a rather standard exclusion for employees that work less than 20 hours a week, that's out beginning in 2025, okay? So pay attention to this. This is an important rule. It's going to bite you. It's also one of those things I think it's sort of you give and take back because remember, the 5,500 rules have changed now for purposes of the 100 participant threshold for audit. You only count as a participant if you have an account balance. So all these folks that are eligible but weren't participating, we don't have to count them anymore for the audit requirement. But now, lo and behold, beginning in 2024, we have this new group that may start contributing, that may bump you up over that 100 limit. So pay attention to this. It's a pretty important change, I think.
Mandatory, yep.
Yeah. Okay, great.
Student loans, something that all been hearing a lot about in recent months, made its way into the news, into our politics. How is Secure 2.0 impacting?
Well, it's probably one of the most talked about provisions because if you look at statistics, there's $1.8 trillion in student loan debt. And what studies were showing is that a lot of the younger employees who are burdened with this debt were not deferring into plans, which makes it more difficult then for a plan to pass its non-discrimination tests, et cetera. So even before Secure 2.0, there were a few firms that were matching, quote unquote, student loan payments that were being made by their participants. It actually ended up being a non-deductible employer contribution, and it wasn't anything that's was formally authorized, only through a private letter ruling, which is something that only the employer that gets the ruling can totally rely on. So what Secure 2.0 did was actually codify this rule that allows an employer to match student loan payments in the plan. So the match would go into the plan while the individual is still making payments to the loan processing service. And that way, at least the participant was getting something in the plan, encouraging them to continue to save for retirement. This is an optional provision. It can be included in a 401k, 403b, governmental 457b. Aside from it being kind of a match of a deferral, which is really a loan payment, everything else is treated the same with respect to the matching contributions. They're done at the same rate as the matching formula laid out in the plan. They're eligible to receive matching contributions under the plan. So it really is a good provision. It is optional, I'll say that, and we are seeing a lot of interest in doing this.
Hey, Jeff, jump back to the prior slide if you could real quick. I just want to emphasize a couple points there. One is that, remember that the third point there, it applies to qualified student loan payments. So that's a student loan incurred by the participant, not the participant's children, for example. And also, I think this is going to come up more because look at the last point. Remember, student loans were suspended as part of all of the coronavirus COVID stuff. But those student loans are reinstated October 2023. So that's coming up. So I think that you may have interest from your employers in adding a provision like this to the plan.
Right, okay. Right. And there are some, as I mentioned, some firms have already been doing this, so that at least there's some framework to put this in place.
Yeah, great, great.
Awesome. Something else we've been hearing a lot about is the lack of Americans' financial cushion and ability to withstand sudden, unforeseen financial hits.
Right.
As far as emergency savings, what do we have in 2.0?
Right. There is a new provision that would allow an employer to add another bucket, so to speak, to the 401k arena that would be called an emergency savings account. And this is optional for 2024 and later. And the individual would be able to, this is only in 401k, 403b, or 457b plans, they could contribute on a Roth basis. Only strictly after-tax Roth basis, up to $2,500 for this emergency savings account. And the investments would have to be something that's pretty safe, interest-bearing account or capital preservation account. And so we'll see this potentially being added. Now, it will be an extra cost. So that's one of those considerations that plan sponsors and their committees should take a look at. If it is in the best interest, that's great. And as long as the costs are reasonable, that's just fine to add that to the plan.
Yeah, like I was going to just add like extra cost because now think about this really. So what this is saying is that in addition to making 401k, you can put money away into this emergency savings account that you can later withdraw from. But you get 4 withdrawals per year with no charge. So think about that from the record keeper's perspective. Somebody's got to pay for that. So that's probably going to be the employer. So I don't know if that'll be a detriment to employers adopting this or not. But I think that's the added cost we're looking at for this. But policy-wise, it's probably not a bad idea.
Right. We'll talk a little bit about something separate called the emergency distribution. John will cover that.
Yeah.
So while we're on withdrawals, what about cash outs? How have those been impacted?
Okay, so now remember, what we're talking about here on the cash out limit, Remember, the general concept is I can't force participants out of the plan. I can't make a distribution without the participants' consent. An exception to that is small account balances. Since I don't know when, the dollar limit's been $5,000 and under. So that actually, and that's not indexed. You know, a lot of these dollar limits are always indexed for cost of living. This isn't indexed. But under Secure Act 2.0, that $5,000 cash out limit's been bumped to $7,000. So remember, the rule is if the account balance is less than $1,000, send them a check. Between $1,000 and $7,000 now, roll them to an IRA. But you can force those small account balances out of the plan without participant consent. And that applies to 401k, 403b, and government 457b plans.
Okay. I know there were a number of accommodations made to help address difficult situations. John, can you kind of start talking us through some of those?
Yeah, sure. So as Jenny mentioned, Jenny talked about the emergency savings account. Now this is something different. This is just a provision you can put in the plan to allow for emergency distributions. Okay, so an emergency distribution is a distribution one time a year up to $1,000. So if you have a participant, you know, we've read about the stories of the person who has the $400 auto repair bill but doesn't have $400 to pay for it. So you can do an emergency distribution out of the plan up to $1,000. An emergency is an unforeseeable or immediate financial need. It's basically a personal expense. Rely on the employee's written certification. The 10% penalty doesn't apply. The participant can later repay that emergency distribution up to 3 years. If I repay, it's a taxable distribution. If I repay, I can claim a refund on my income tax return. And it applies to 401k, 403b, and 457. So once again, another way for participants to access money in the event of an emergency that's different than the emergency savings account, okay?
Okay. Next topic, domestic abuse.
Yeah, domestic abuse. So, so here's just the concern is that you've got somebody, a participant, that's a victim of domestic abuse, and he or she may need money to escape that unsafe situation. So the plan can allow for a distribution now for domestic abuse victims. The participant certifies that he or she is a victim of domestic abuse. The distribution has to be made within 1 year of the date of the domestic abuse. It doesn't apply, the 10% penalty doesn't apply, but once again, it's taxable income, but I have 3 years to repay it and claim a refund if I'm able to do that. So it's optional, but it's a way for participants to access funds, if the plan allows it, if they're victims of domestic abuse. Jenny, I don't know, I've always sort of been the feeling that these are retirement plans.
Right.
And they really ought to be money for retirement. I may have to tell you no today, but if I tell you no today, you'll thank me later. Do you have just a general thought on whether these provisions are good from a policy perspective?
Yeah, that kind of gets back to, is this in the best interest of the plan participants and beneficiaries, knowing that the plan is set up for retirement income, to generate retirement income. It's on the one hand, it's great to be, to allow these distributions to help out participants, but in the long run, and this is that difficult conversation that the plan sponsor and plan committee has to have, is that still in the best interest if the goal really is to save for retirement? And that's where you need to document those conversations and those decisions, because if a participant were to later on claim that, no, I should have had these available to me, the plan sponsor and committee would have this documentation say, well, we considered that, but we really felt this was in the best interest to really preserve your savings for retirement.
Yeah, so all these optional provisions we're talking about right now open up the plan to participants to take an in-service distribution, but you need to think about it, okay? I don't want to discount the seriousness of these circumstances,
right.
But think about what the purpose of the plan is when you talk with your clients. Just be aware of it.
One thing I might jump in on the previous, on the emergency, and this too, where it's self-certification. That means that the participant, the plan sponsor, basically needs to take the word of the individual. There still should be some kind of documentation for the files for processing the distribution. You have to make sure you're reporting accurately, so there's still some kind of documentation, but again, it's a self-certification. And then there is the caveat that if the employer has knowledge, actual knowledge that maybe there wasn't an emergency situation, there's the potential to be able to deny that distribution.
Okay.
All right. One more set of difficult circumstances that there may be some relief for.
Yeah, so kind of continuing on the same theme, these are distributions for FEMA-declared disasters. So this is different than the hardship distribution provision under the plan. Once again, it's optional. It's for disasters on or after 1/26/2021. I bet if I went around the room and polled folks, there are very few of us that don't live in a FEMA-declared disaster area based on what's happened across the country in the last few years. But think about this in terms of the COVID emergency distributions that were allowed. The big difference, these distributions are limited to 22,000. That's down from 100,000 under COVID. There's also the double participant loan limit. So if I'm in a FEMA-declared disaster area, I can do a loan up to $100,000 or 100% of my vested account balance. Payments can be extended on those loans, but you need to check and see under the FEMA.gov if this is a FEMA-declared disaster. Once again, it's an exception, can be repaid, not subject to the 10% penalty. And last, let me just talk real quick on this one. So this is for terminally ill individuals. Now I want to stress, this is not a new distribution event. So I can't come in while I'm still working and say I'm terminally ill, can I take a distribution? This simply applies to whether or not a participant who takes a distribution, for example, I terminate employment, I take a distribution. If I have a terminal illness, that's the bad news. The good news is I don't have to pay the 10% penalty. So I don't know how great that is, but the point here is this is not a new distribution event, okay? It's just not subject to the 10% distribution for early distribution if I have a doctor's letter that says I've got 7 years, okay? So just be aware of it.
Much happier topic, births and distribution and adoptions.
Yeah, let me just cover this one real too, because like Jenny mentioned, some of these provisions are holdovers from Secure Act 1.0. So some of you may remember, this is a provision you could put in the plan that if a participant had a qualified birth or adoption, they could withdraw up to $5,000 per birth. So I think for Octomom, that would be $40,000 that she could have withdrawn. But the point is, there was a provision that allows you to repay it. Once again, I took the distribution, I can repay. What Secure Act 2.0 said was that repayment period is 3 years. And that kind of coincides, remember, with the idea of filing an amended return to claim a refund. That's a 3-year period. So that's effective for distributions made after 12/29/2022. It applies to 401k, 403b, and government 457b.
Okay, well, bring us home on elective deferral failures.
My last one for a little bit, then I'll be quiet for a moment. This is really important. Okay, so think about this. This is a safe harbor correction for plans that allow automatic enrollment. Now, automatic enrollment is a good thing, right? I think we can all agree on that. But the bad thing is when your client calls and says, hey, you know what? I've got a bunch of employees. I forgot to automatically enroll. What do I do? Well, typically when you self-correct something like that, you have to make up the match they would have otherwise received, but you also, as the employer, have to provide a QNEC equal to 25%, used to be 50, now it's 25%, of what they would have deferred. So if I should have been auto-enrolled at 5% but wasn't, the employer would have to put a QNEC in of 1.25% plus the missing match. But if you correct that failure by the due date of the 5,500, 9.5 months after the end of the planned year, you don't have to do the QNEC, all right? Now, this is important because that safe harbor's always been there, but it was supposed to expire 12/31/2023. Secure Act 2.0 makes it permanent. This is a good change. So here's the concept. You get the call from your client. I should have enrolled 10 employees last April, or April of 2022. What do? Well, it's April 2022. 9.5 months after the end of the plan year is 10/15/23. You can still correct that with no QNEC. Do the match, no QNEC. And this also applies to participants who make affirmative elections in an auto-enrollment plan. So let's say you've got a participant who actually filed an affirmative election to defer 5%. That wasn't enacted, but it's an auto-enrollment plan. You can still take advantage of the safe harbor. So it's a real good provision. You have to do a 45-day notice telling the employees you made a mistake, but you don't have to do the QNEC. And I also want to mention that under Secure Act 2.0, self-correction has been hugely expanded. You can basically correct now any eligible inadvertent mistake. I hope I said that right.
Right.
But that's basically anything that doesn't involve tax avoidance, misuse of plan assets, egregious. So, and there's no time limit. Right. All right, there's no time limit anymore. So when your clients call you and tell you, hey, we made a mistake, tell them, look, it's probably something that we can self-correct. And oftentimes you can do that with a retroactive plan amendment now, as long as you're not decreasing benefits, you're adding something to the plan.
Right. I always like to emphasize the fact that the Department of Labor and the IRS, for that matter, they really want to work with plan sponsors to keep the plans, bring the plans back into compliance, just make sure they're whole again, because they know how very important these balances are to the future for retirement income. So they're very willing to work, and the expansion of the self-correction program is testimony to that.
Yeah. So this safe harbor is a great one for auto-enrollment and auto-escalation plans. It applies to both. We just wanted to include it because it was supposed to safe harbor at the end of the year, but no more. It's permanent.
Okay. Before we change gears to litigation, I would like to confirm with the booth in the back that we just had some magic time pop up on the clock. I'm not a soccer guy, but I feel like I'm in soccer because there's just new magic time available. And if that's not correct, please correct it. So, litigation, Jenny, what is going on and the impact of Hughes versus Northwestern?
Well, you've probably heard of this case. It's been around since 2016. And just a little bit of background, I won't go into all the nitty-gritty legal terminology, but it was the plan participant, plaintiff, that claimed that Northwestern had mishandled their 401k plan, had a breach of fiduciary duty because they didn't benchmark their fees. They included retail funds, more expensive retail funds, when institutional funds were available that were comparable. Also that they were paying excessive fees for record keeping. And so when this case first came out, both the district court and the circuit court dismissed it. It said, no, you really don't have a case here, and left the plaintiffs kind of, what am I supposed to do now? But the Supreme Court decided to hear the case, took a look at it, and decided, wait a minute here. I think there's some merit here in their claims. I'm going to send this back to the district court the circuit court, to have them re-look at this and check to see if there really is some standing for the case. And when the district court did when the circuit court did re-look at the case, they indeed said, yes, there are probably two causes for a case here. And what this does is really emphasize the idea of what is the pleading standard. And I want to focus on that center square. I'm going to read that. When analyzing a motion to dismiss, courts must construe the complaint in the light most favorable for the plaintiff. Accept all well-pleaded facts as true and draw reasonable inferences in the plaintiff's favor. So that's really giving the plaintiffs the benefit of the doubt. What we think will result from this is that maybe there will be an uptick in more cases because it's more likely that participants will second guess what plan sponsors are doing, and their cases are probably more likely to go forward. Now, if I can skip to the very last slide in this. I think what that tells us, though, with respect to a plan sponsor's responsibility, that never changed. It does, however, emphasize the very important process, prudent process of not only selecting investments up front, benchmarking those investments, monitoring them on an ongoing basis, making sure they are replacing poorly performing investments with better investments, using an investment policy statement, using all these practical and tactical steps to make sure that their investments are meeting the standards of, that prudent process in selecting and monitoring those investments. And I couldn't help but just smile when Luke was speaking beforehand about the importance of benchmarking and the tools that RPAG has, and also the idea of going out for bid, an RFP every 3 to 5 years. That's kind of a general rule of thumb, even though it's not a requirement. It's certainly been out there as a rule of thumb. And to know that RPAG has those tools that makes that easier is just a huge leg up for advisors helping plan sponsors and committees.
I'll get you that 20 when we get off stage. Thanks.
Yeah, I was going to add, because remember what we're talking about here is if your client gets sued, what they want to try to do is dismiss that action at the beginning versus having to actually go through all the discovery, which adds up the costs. So the plaintiff files the complaint. What the courts are saying now is that if the plaintiff alleges you haven't been benchmarking the plan, if the plaintiff alleges that there are less expensive share classes, if the plaintiff alleges your plan is more expensive than comparable plans, those are sufficient facts now to get past the motion to dismiss. Okay, so in terms of your due diligence, at a minimum, benchmark the plan. If you're not using the lowest cost share class available, you should have a good reason why you're not doing that, okay? And I also think it's important to always add a sleeve of low-cost index funds to your lineup, just to defeat the participant who says, I was forced into higher cost share classes, higher cost funds. So I think you follow those 3 steps, I think you've got a pretty good defense.
Right. Right. And emphasize the idea that you don't have to have the lowest cost funds all the time. The Department of Labor states reasonable fees for the services and investments provided. So as long as you can, again, document and have that in the file that we chose these investments because they are reasonable for the extra services that we are receiving, that's good for the Department of Labor.
Right.
If I may ask a question, as someone who doesn't really understand how the rules on the legal proceedings work, would there be any chance of cases that had been dismissed previously that may not have gone down the road that was laid out here about the standards that have to be met that might be refiled and think they wouldn't be dismissed under the new setting?
Yeah, that's actually happening. But so in other words, before the pleading standards were more strict, so as the plaintiff, I got knocked out on a motion to dismiss, but as long as I'm still within the statute of limitations, I could refile that under the new pleading standards. But that's the key, is the statute of limitations may have already run on the claim.
Thank you. Let's switch to something that's apolitical, everybody agrees on, may not even know that it's been discussed in the audience. John, ESG, what's happening?
Yeah. Well, so ESG is interesting because, as you're all aware, the Department of Labor promulgated an ESG rule at the end of last year. And it's interesting, if I read what the people who are commenting against the ESG rule said, it makes me wonder, did they even read it? Because, let's go on to the next slide if we could, because so this new rule took effect January 30th of this year. And all it says is that a plan fiduciary may consider ESG factors, but you're not required to per se. And I think if you look at that purple language there on the slide, where it talks about, I think this is a good way to think about this, is ESG factors can be used to evaluate value, the risk and reward of an investment, but you can't use it to promote values, whether or not something has a social mission. The second point there, the rule does not allow you to sacrifice the financial health of the plan to pursue other goals. So I think what that means is is you can take ESG into account, but you need to run your fund through the scorecard. And if it's scoring, say, a 7 or an 8, and there's a plan in the same asset class that may not be ESG scoring a 9 or a 10, and you're not using that higher score fund, why not? You can't say, well, we chose the lower performing fund because of the ESG factor. That's not good enough. So I think the rule is pretty clear. ESG can be a factor, but it can't be a controlling factor. Let's hit the next one really quick since we've got extra time to keep talking.
Plus, this chair is
Something went
comfortable.
wrong
I've got a
here.
remote. Now let's use it.
We're cutting into Jeff Elvander's time right now, I think, but we'll keep talking for a few more minutes here. But one of the more nebulous provisions in the new rule, it says that the plan sponsor can take into account participant preferences in selecting funds under the theory that if I add funds my participants want, that might encourage participants to sign up, might encourage them to save more. I can take that into account. But once again, I don't think that means, like, for example, if I'm selecting a large cap blend fund and I've got a choice between an ESG fund my participants want or a higher scoring large cap blend fund, I think I need to select that higher scoring large cap blend fund, not the ESG. But then I also think, though, once I've done that, I think if I wanted to add an ESG fund to the plan per my participant preference, I can probably do that. But once again, that core lineup, I think, needs to reflect non-social factors, financial factors only under the ESG rule. Okay? So use ESG, but use it cautiously.
Yeah. And cautiously is the word, because I think the phrase greenwashing in
Yeah.
names, and that's, that's one thing that the regulations didn't do. It didn't define what is an ESG investment. And so I've seen cases where they've simply just changed the name, included ESG or some kind of, feel-good name,
Yeah.
and didn't change anything in the lineup.
Yeah.
And so what makes that an ESG fund?
Yeah, but I think the takeaway too from this, the last slide, if we could real briefly then, the bottom line there, so there, on January 26, 25 states sued the DOL in connection with the DOL's rulemaking. In Texas, sorry Jeff, but that's where a lot of this stuff ends up, it seems like. But here's the point: is the court is allowing the lawsuit to proceed, but they're not delaying the rule's effective date. Okay, so the rule's effective today. ESG is a factor, but it can't be the controlling factor. Now that could change if at some point the district court decides to postpone implementation or put a stay. But right now, this is the rule. The rule's in place. It's in effect right now. Okay.
All right. Any closing thoughts?
I will say that a prudent process throughout, documenting that process, the meeting minutes, having your agenda spell out what topics you're going to, in the plan sponsor and committee, what topics are going to be addressed. Have a calendar where you lay out what topics are going to be discussed through the next few months, especially since we've got several different effective dates for the various optional provisions. So you can schedule discussions with respect to those particular optional provisions. So prudent process. If it was a drinking game, prudent process.
Yeah, I would emphasize that because like sometimes I like to say that, remember with ERISA, under ERISA, nobody will ever ask you, why did you pick Fund A instead of Fund B? What they'll ask you is, what process did you follow in selecting Fund A versus Fund B? And if you have a prudent process in place, you should be okay. The other thing to think about in a closing comment is help your clients understand who is a fiduciary with respect to the plan. Now, certainly if you're a named trustee, you're a fiduciary if you're on the plan committee. But the concept is, if you're a decision maker with respect to your company's plan, you're a fiduciary. And I like to tell my clients sometimes, there's the old adage, no good deed goes unpunished. And what I mean by that is that as an employer, you're trying to do a good thing. You're setting up this plan for your employees, you're trying to do a good thing. But once you've done that, you've done the good thing, you've set up the plan, now you have fiduciary responsibilities that you have to comply with. But I think with all the tools that we provide at RPAG, it's easy to meet that standard. But just be aware that there is a standard and do your best to comply.
Yeah, in this day and age, it's easier to be a good fiduciary than a bad fiduciary.
Yeah. All right.
Your Honor, the defense rests. Thank you very much.
All right, thank you.